Hi everyone, and welcome to Connected With Latham, where we discuss ideas, legal developments and business trends shaping the global economy. My name is David Walker and I'm a private equity M&A partner at the Latham's London office. In this episode, we want to discuss an increasingly fraught situation around environmental, social and governance matters, or ESG. Regulators and stakeholders on both sides of the Atlantic have trained their sights on ESG considerations, creating an ESG backlash that appears to have picked up steam. In turn, private equity firms will need to approach their messaging and strategies with more transparency to mitigate the risks. To discuss how private equity sponsors can navigate these issues, I'm delighted to be joined by my colleague and global co-chair of Latham's ESG practice, Betty Huber. Betty helps clients shape and develop ESG strategy, oversight, reporting, and other programs to drive real value while providing solutions to carefully address, manage, and mitigate risk. Her more than 25 years of experience providing sophisticated and commercial advice will no doubt provide useful as we wade through an evolving ESG landscape. Welcome to the podcast, Betty.
It's a pleasure to be here, David.
So let's start by looking at the scale of the ESG backlash, which varies across geographies and sectors and creates challenges and I guess opportunities for private equity funds as they look to navigate an often politicized topic. What recent activity on this issue have we seen in the US, Betty?
David, in the United States, Scrutiny has really focused on asset managers, private funds, financial institutions, insurance market participants, proxy advisory firms, and the so-called ESG raters. We've seen quite a stark legislative and political split here in the United States. So at the federal level, the securities regulator, the Securities Exchange Commission, has generally taken a progressive ESG stance in light of the Biden administration, which is a Democratic administration here in the United States. And so for instance, the SEC has increased proposed and final regulations of environmental, social, and governance, or so-called sustainability matters for private funds, which is really kind of a new foray for that agency. In contrast, conservative or Republican states, such as the states of Florida and the state of Texas, have introduced legislation and taken other actions in the opposite direction. For instance, we spend a lot of time thinking about Florida's House Bill number 3, which effectively limits the use of certain ESG factors in investment considerations. We have a variety of projects right now analyzing how Florida funds can invest in certain of our sponsor and private funds projects that are pushing forward ESG objectives, but at the same time threading the needle to make sure that Florida funds are satisfied with the objectives as well. Continuing on the federal level, U.S. state attorneys generals and very high-ranking members of Congress, which is the legislative branch of the United States government, and others have made various legal arguments to question or restrict ESG strategies. These arguments cover a broad swathe of topics, but they include allegations of alleged antitrust violations to the extent that clients or funds are engaging in so-called climate cooperatives or membership organizations, breaches of fiduciary duties, because of course asset managers and funds are investing other people's money and need to invest it to seek maximum returns, financial returns. Other allegations that diversity, equity, inclusion quotas and programs violate United States civil rights laws, and the general kind of topic and allegation that ESG factors are not pecuniary and really just values ideologically or politically motivated, which typically is not the case, but these are the allegations. Sponsors have also been required to navigate actual state attorney general subpoenas and federal demands for information and documents, which give rise to a whole host of issues such as information sharing, confidentiality concerns, and these are things that we're helping our clients navigate today.
And so do you think it's fair to say that the ESG backlash has been less pronounced on this side of the Atlantic?
Yeah, David, I would say that that's a very fair observation and question. So I think that the anti-ESG backlash has so far been less of an issue in the European Union and the UK. There have been fewer explicitly anti-ESG legislative and regulatory developments. However, it's also fair to say that scrutiny of ESG strategies is growing on both sides of the Atlantic. UK and European regulators, limited partners, and other stakeholders' concerns differ from those in the US to some extent, and what we see is that in the UK and the European Union, there's quite a focus on the veracity, accuracy, and reliability of ESG claims and commitments that are stated publicly. So this is something that is called greenwashing. So the allegations of greenwashing, or making your ESG commitments or programs seem perhaps better than they really are, those allegations are becoming more common as ESG-related marketing claims are studied in depth. But I will say that that is something that's a focus on both sides of the Atlantic. You see it with the SEC names rule, which is really meant to eradicate greenwashing. And also, private companies are being sued on their disclosures and trying to say that they're overstating their green credentials.
So then, fair to say that there is a heightened focus from regulators and stakeholders on both sides of the Atlantic. So then let's turn to what PE sponsors can actually do to facilitate a consistent and transparent approach in relation to their ESG strategies.
Yeah, that's a really good question, David. So both in the EU and the US, this heightened focus does result in private equity firms becoming more rightly cautious about their public ESG claims and just taking more of a fine-tooth comb and making sure that they're accurate, which is always a good thing. Accurate messaging is key to mitigating risks associated with ESG, particularly those greenwashing allegations I mentioned just before. And so, best practices would be sponsors ensuring that their public statements are consistent, and then that's accuracy is required, not just public statements, but across internal operations, investment decisions, and interaction with portfolio assets. So that really puts importance on the governance of all of this at management levels, board levels, as well as down in the portco levels, and communicating up to the sponsors. And, on the day-to-day deal side of things, the deal team also has to be mindful of these political environments and jurisdictions in which they operate and be aware of potential policy changes. We see that in the due diligence that we do and assist our sponsor clients with on a day-to-day basis. I think really the point is certain geographies or industries will be more vulnerable to an ESG backlash, and it's something we need to keep in mind.
And do you think we're seeing private equity sponsors then kind of back away from ESG in relation to either investment focus or fundraising strategies?
No, this is a lot of noise, but I think sponsors are likely going to continue to pursue assets aligned with their own investment strategies. And for some, this may include investments in strategies that have been disavowed by ESG-focused investors or not. But the fact remains that despite these allegations, there's a reason why ESG does drive long-term value. And this kind of political climate may dampen it a little bit, but not change at all the basic thesis and investment strategy in my mind.
So it sounds like ESG will remain a focus area for the majority of private equity investors in the years to come. Thank you for joining me today, Betty. It's been an absolutely fascinating oversight of the ESG issues facing private equity.
David, thanks so much for the fascinating discussion today. It's always a pleasure to be with you.
Thanks very much to everyone for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or indeed wherever else you get your podcasts. If you'd like more information about the topics in this podcast, please email us from the links located in the show description, and we'll be very happy to help you. In the meantime, we look forward to you joining us again in our next podcast. Thanks very much.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.